created by the General Assembly, which is required by the Virginia's Constitution. Those people sitting on those entities, be it the discipline board or the district committees, sitting in judgment of lawyers and reviewing complaints of the public, are not appointed by the General Assembly.
Ms. Daniel, can I ask a question regarding the statutory scheme here? As I understand it, a lawyer who is subject to disbarment in the Commonwealth has the option to refuse adjudication before the board and seek a hearing before a court. Did you do that in this instance?
I did not do that on purpose because the certification from the district committee was faulty. That district committee cannot sit in judgment of a lawyer and issue what is the equivalent of an indictment to the wrong court to have someone tried before a court that has not subject matter jurisdiction.
Wouldn't that have been an argument that you could have made before the court?
My attorney filed a memorandum along those lines and failed to argue it, waived argument at the beginning of the hearing and did not inform me that he had done so. So yes, it was presented. It was not argued because my lawyer did not argue it. I couldn't control that. I did ultimately fire him, and the bar appointed a guardian ad litem for me, appointing him as my guardian ad litem when they had no authority whatsoever under any rules, any statutes, any constitutional provisions to appoint a guardian ad litem in a misconduct case. And then they put in a footnote written by John Gibney's wife. John Gibney is a U.S. District Court in the Eastern District of Virginia. She is a lawyer, deputy county attorney in Hanover. He put in a footnote in that opinion written March 23rd, 2019, on my father's birthday, that I didn't need a guardian ad litem because I hired a lawyer. That is an outright lie in that order.
Can I back up a little bit? So we have some information in the record that the part of this litigation made its way up to the Virginia Supreme Court. Has this issue been decided by the Virginia Supreme Court in your case?
Not in my case, no.
Has the court decided it in some other case?
The court has never addressed this full issue, or these full issues rather, of subject matter jurisdiction and due process in any other cases to my knowledge. They've touched on it, but they've never gotten to the essence of it. If the board doesn't have subject matter jurisdiction and the district committees don't have subject matter jurisdiction, then those proceedings before those entities, before supposedly quasi-judicial officials appointed by the Supreme Court, not the General Assembly, and appointed by Council CIL, the governing body of the state bar, not the General Assembly, to sit in judgment of lawyers. That has never been addressed fully in this state.
So let me go back again to the point you made about your lawyer not presenting the argument. That's not, unfortunately, not atypical in cases that we see. And the general rule is that the lawyer is the agent of the client. The client is responsible for any commissions or omissions that the lawyer fails or doesn't make. So why shouldn't that apply in your case? Your lawyer didn't make the argument, so the argument is waived.
I did not waive the argument. My attorney waived the argument without my permission.
Right, but your attorney was acting as your agent at the time, and I mean the cases are legion that if that happens, absent some extraordinary circumstance, the client unfortunately has to accept the consequences of the lawyer's waiver.
I did not know he waived the argument until after the entire two-day trial was over. And then I found out he waived the argument. The day of the first day of trial, I asked the court reporter to provide me a transcript the next morning, overnight, expedited. Court reporter was hired by the Virginia State Bar, not me. They would not let me have my court reporter there.
Were you at the trial?
did not provide me that transcript.
Were you at the trial?
Not when he waived the argument. No, I was not. I
Were you there for the 2 days?
was there for 1.5 days on his instructions. I missed the first morning on his instructions because he did not want me to be called as the first witness for the bar. And I understood that, having prosecuted lawyers for 8 years for the state bar and defended them for 28 years, I understood that theory. So I was not there when he waived the argument. I did not know until after the case was over, completely over, that he'd waived the jurisdictional arguments. The fact that there was no subject matter jurisdiction in that board to try any lawyer, not just me, but any lawyer, or that he didn't argue due process of law was denied because the board didn't have subject matter jurisdiction. Now, those are constitutionally guaranteed rights in this country. Yes, I ended up firing him the second day of trial before the board. And that's when this woman right here asked the board to appoint him my guardian ad litem, and they did it. They had no right to do so. There's no rule or law that allows the State Bar Disciplinary Board to appoint a guardian in a misconduct case. I challenged it and I fired him. And they had to rescind that order after Ms. Schoenfeld consulted with Mr. McCauley's office, who's ethics counsel at the State Bar, and he informed her that I was correct. However, they put the footnote in the order stating that I didn't need a guardian ad litem because I hired a lawyer. That's an illustration of the corruption that goes on inside of the Virginia State Bar that is not confronted. Lawyers in this state are petrified of the State Bar. Not a single lawyer out of 34,000 active lawyers have been willing to do any research for me, anything to help me prepare for this day.
Ms. Daniel, can I go back to this issue of waiver? And I don't mean to beat a dead horse here, but you said that the Supreme Court has never adjudicated this issue, but the Supreme Court has in a case called held that as a matter of law, the board has jurisdiction to conduct disciplinary proceedings and sanction attorneys whenever an attorney does not timely demand to be heard by a 3-judge panel of circuit court judges. That's what happened in this case.
But Your Honor, there is a rule, 13-2. It's a procedural rule for the State Bar. And there is a statute, 54.1, 3915, that says that the Supreme Court of Virginia cannot pass any rules that are contrary to the statutes. If you look at Consumers Union, which I mentioned earlier, in 54.1, 3935, you will find that every attorney has the right to be tried by a court, not a disciplinary board, not a district committee, and that those attorneys are entitled to have a state court impose discipline on them, not the State Bar Disciplinary Board, not the State Bar District Committees. The rules that allow the State Board and the State Bar Disciplinary Board and the State Bar District Committees to impose discipline are contrary to Consumers Union, contrary to 54.1, 3915, and contrary to Rule 13-2 of the Virginia Supreme Court for the procedures that can be enacted, if you will, or promulgated by the Virginia Supreme Court for the discipline of lawyers. It is clear from the constitutions, from the statutes, from the rules, that particular rule, 13-2, that the courts have the sole jurisdiction to impose discipline on lawyers in Virginia, the sole jurisdiction. Therefore, if the district committee imposes discipline, it's illegal. If the disciplinary board imposes discipline, it's illegal. Those orders avoid ab initio the minute they're entered and promulgated out to the world, sent out to the world. They ruin people's reputations. They ignore the public. There's another statute that's critical. It's 54.1, 3910, which says the bar has only the authority to investigate and report. Investigate and report. It's limiting, it's mandatory. They dismiss 81% of their cases every year that they get with little or no investigation. I have an audio video of the past president, Jay Myerson, speaking to the Senate of the General Assembly Judiciary Committee on February 2nd, this year, 2022, proudly saying to the Senate Judiciary Committee, the state bar dismisses 81% of their cases that they get, complaints they get, with little or no investigation. And often the lawyers don't even know the complaint was received. Well, if you look at the YouTube video that the state bar puts out for complainants, so they think the public thinks they're going to get fairness. That's not the procedure they have in their YouTube video. In their YouTube video, they have the procedure of we receive the complaint, we review the complaint, we send it to the respondent has a chance to respond, the complaint then has a chance to rebut. They don't do that in 81% of 4,000 cases a year. But you know what they do? They target minorities, women, solo practitioners, and small firm members. I've got 27 years of verified statistics where no large firm member and no well-connected lawyer got any public discipline. How does that protect the public? That is why I'm here. The public deserves to be protected. Lawyers are part of the public. They deserve to be protected. We as lawyers, all of us are lawyers, just about in this courtroom. We as lawyers are entitled to due process. We're entitled to be tried by a forum that is subject matter jurisdiction. You cannot waive that. Even if my attorney waived it, I can't waive it. I have the right in any forum at any time to attack a void ab initio order. And that's exactly what I'm doing here today. I waited for this moment to come before the U.S. Fourth Circuit Court of Appeals. I could have gone to the U.S. Bankruptcy Court. I could have gone to the U.S. District Court. I chose to bring these issues to the Fourth Circuit Court of Appeals because they're jurisdictional issues. Due process is guaranteed. Subject matter jurisdiction is guaranteed. It cannot be waived. I don't care what my lawyer did. I didn't waive it. And I have the right to attack a void order when it's void ab initio or purely void, whether they use those special words or not, in any forum at any time.
All right, Ms. Daniel, you're a little bit over your time now. You're bleeding into your rebuttal, so you have some time for rebuttal. Thank you very much. Ms. Schoenfeld, we'll hear from you.
May it please the court. My name is Elizabeth Schoenfeld. I'm a senior assistant bar counsel for the Virginia State Bar, and I was appointed as prosecuting counsel for this reciprocal discipline matter pursuant to local rule 46G10. I served as lead counsel for the Virginia State Bar for the underlying proceeding that resulted in the revocation of Ms. Daniel's Virginia State Bar license. The background of the underlying proceeding is that on September 20th of 2018, a subcommittee of the 3rd District Committee of the Virginia State Bar certified charges against Ms. Daniel. The certification, which is in the joint appendix at 655 through 675, laid out detailed allegations of fact and violations of the Virginia Rules of Professional Conduct. Now, as the court noted, Ms. Daniel had the opportunity to demand to have the matter heard by a 3-judge circuit court pursuant to Virginia Code Section 54.1-3935, and also the Rules of Supreme Court of Virginia, Part 6, Section 4, Paragraph 13-18A. And I'll refer to that section of the Rules of Court a few times, and in the future, I'll refer to it as Paragraph 13.
Now, her primary argument, as I understand it, is there was no jurisdiction from the get-go, that the state bar has no jurisdiction. What's your response to that?
Certainly. Well, she talked about the Consumers Union case. That case was not cited in her briefs. I believe it was cited in additional filings before this court, but not in her briefs. But if you read the Consumer Union case, the section that she cited is dicta. What the Consumer Union case was about was whether the Virginia State Bar and or the Supreme Court of Virginia were liable and responsible for attorney's fees regarding an advertising rule that had been promulgated. And the section that Ms. Daniel has referred to simply discusses the court's understanding of how the disciplinary system worked in attempting to ferret out who does what, when, and why. And to continue with the
So,
authority.
Ms. Schoenfeld, just to be, so I understand this process, the statutes themselves do not expressly set out the procedure that the Supreme Court has created for discipline. Is that right?
They delegate authority to the Supreme Court
Right.
of Virginia to create that process. And they specifically recognize the disciplinary board in section 54.1-3935. And I can walk through that.
Well, is there any limitation in that statute itself that suggests that the board can't mete out discipline?
The board can't.
Can't.
Oh, absolutely not. What 3935 says is that any attorney who is the subject of a disciplinary proceeding may elect to terminate the proceeding before the bar disciplinary board or a district committee and demand that further proceedings be conducted by a 3-judge circuit court. So that's the legislature saying you can step away from the disciplinary board and go to a 3-judge court, but you have to make that demand, as the court noted. And if you look to, just to back up a few steps, if you look at section 54.1-3909, that's where the legislature gives the Supreme Court authority to prescribe procedures to discipline, suspend, and disbar attorneys. And section 54.1-3910 gives the Supreme Court of Virginia authority to promulgate rules and regulations organizing and governing the Virginia State Bar. And it also states that all persons engaged in the practice of law in Virginia shall be active members of the Virginia State Bar. So reading those together, it states that you have to be a member of the Virginia State Bar in order to practice law in Virginia. And they delegated that authority to the Supreme Court of Virginia to create the rules and processes determining who does and doesn't get to be a member of the Virginia State Bar. And pursuant to that authority, the Supreme Court of Virginia did exactly what it was authorized to do. It created paragraph 13-6A, which authorizes the Supreme Court of Virginia to appoint a 20-member disciplinary board. And paragraph 13-6F states that the board has jurisdiction to consider complaints and certifications submitted to it by a subcommittee or district committee. And as I mentioned, Ms. Daniels' matter was initiated by a certification from a subcommittee. Now, Ms. Daniels' argument in that regard seems to originate from her misreading of Virginia Code section 54.1-3915. And that section states that the Supreme Court of Virginia cannot eliminate the jurisdiction of the courts to deal with discipline. And we saw that actually in the facts underlying this very case. In one of the underlying matters, Ms. Daniels' conduct led to her being banned from the Suffolk Circuit Court. That's in the joint appendix at 2614 and 2620. So section 54.1-3915 says the Supreme Court of Virginia can't eliminate the Suffolk Circuit Court's jurisdiction to do that, and the Supreme Court of Virginia hasn't done that. Now, Ms. Daniel has tried to frame this proceeding as a referendum on Virginia's disciplinary system, but this is a very narrow proceeding. The only matter for the court to decide is whether it will follow the Commonwealth of Virginia's lead and revoke Ms. Daniels' admission to this court. And under local rule 46G2, the discipline imposed by another court is presumed to be appropriate. So the potential bases for which this court could not impose reciprocal discipline would be, first, that the Virginia State Bar procedure lacked due process. And to briefly address due process, Ms. Daniels' briefs, her initial brief appears to argue due process. Her reply brief appears to waive that argument. She talked about due process today, but due process in disciplinary proceedings is defined as notice of the proceedings and the opportunity to be heard. And there's no question that Ms. Daniel had that. She was served with the detailed certification. She filed a detailed response in which she consented to jurisdiction of the disciplinary board. And as she told you here today, that was a deliberate decision that she made. She identified witnesses and exhibits. She had a 2-day evidentiary hearing in February of 2019, which was 5 months after the charges were certified. She was initially represented by counsel until she fired her counsel. The bar, as the court can see in the transcript, did express concerns about Ms. Daniel representing herself and objected to the withdrawal of her counsel on that basis. The disciplinary board momentarily appointed a guardian ad litem for Ms. Daniel. Ms. Daniel objected to that. The board immediately revoked that decision. No substantive action was taken where Ms. Daniel had a guardian ad litem. And although I address it because Ms. Daniel did, all of that is frankly irrelevant to the question of whether she had due process, which is simply notice of the proceedings and an opportunity to be heard. The other potential basis for not imposing reciprocal discipline is that there was an infirmity of proof or facts such that the court could not accept Virginia's conclusions. And for that, I would direct the court's attention to the disciplinary board's memorandum order, which identifies specific findings of fact to support each rule violation. Now, Ms. Daniel argued in her opening brief that there was no evidence to support the findings. That's plainly contradicted by the memorandum order, and it's significant that the underlying facts here were not disputed. The bar's exhibits were admitted without objection. The board's findings were based on letters that Ms. Daniel sent, pleadings she signed, and statements that she made on the record at hearings. For example, 2 of the matters in which Ms. Daniel was disciplined involved her representation of Robin Ruffin. Ms. Daniel filed a motion for a rule to show cause in Ms. Ruffin's divorce case, in which she asked the court to order a non-party to convey an interest in real estate and asked for relief on behalf of Ms. Ruffin's mother, who obviously wasn't a party to the litigation. She told the presiding judge that, quote, "There is plenty of evidence to prove your unfitness to preside over any cases in any court," end quote. That's in the joint appendix at 742 through 743. The third matter involved Ms. Daniel's representation of Mary Margaret Jones in a matter related to breach of fiduciary duty allegations. Ms. Daniel accused a circuit court judge of making a bald-faced lie and raping a trust. She advised the court that the case had settled when it had not, and she asked the court to enter orders and act on that settlement, and she didn't copy opposing counsel on that correspondence until 6 hours later. That's in the joint appendix at 2564 through 2572. So in short, there was ample proof to support every Virginia rule of professional conduct that was found. Ms. Daniel's arguments pertain to the third potential basis for not imposing reciprocal discipline, which is that there's a grave reason why imposing reciprocal discipline would conflict with the court's duties. And as noted, Ms. Daniel has not identified any authority to support her argument that the disciplinary board did not have the authority to do exactly what it did. And as Your Honor mentioned in the Fales case, the Supreme Court of Virginia specifically ferreted out not just that you only get a 3-judge circuit court if you demand one, but that you have to demand it properly in accordance with paragraph 13. And if you don't complete those steps properly, then that opportunity is waived.
Can I ask a procedural question about what happens when the board enters an order of discipline? Is there a right of appeal after that?
There is, and it is an appeal of right to the Supreme Court of Virginia. And Ms. Daniel's appeal was dismissed on procedural grounds because she failed to perfect it.
So the court didn't reach the merits of any subject matter jurisdiction argument?
Correct. So in closing, there's simply no basis to overcome the presumption of imposing reciprocal discipline. And I would ask that the court impose reciprocal discipline and revoke Ms. Daniel's privilege to practice before this.
All right. Thank you, Ms. Schoenfeld. Ms. Daniel, you have 5 minutes for rebuttal.
Thank you. As I said, I'm not here for myself. I'm here for every single lawyer who came before me, who's practicing now, and who will come ahead of me, who is subject to this illegal disciplinary system that's been set up by the Virginia Supreme Court, legislating from the bench which is not what a Supreme Court is supposed to do. We've heard a lot about that recently in the news about the US Supreme Court. However, this Virginia Supreme Court has done exactly that, because under the Virginia Constitution, only the General Assembly can set up courts to determine people's rights in this Commonwealth, including lawyers, and only the General Assembly can set up, or appoint judges. The Supreme Court appoints the disciplinary board members, not the General Assembly. They sit as judges, just as circuit court judges sit. They impose the same kinds of penalties on lawyers or dismiss cases which harm the public, just as a three-judge court can do in the circuit courts in Virginia. Secondly, the council, the elected body of the state bar, not even the Supreme Court, appoints the district committee members to sit in judgment and mete out discipline or dismiss complaints that they actually get. You know, part of that, 19% that aren't dismissed by the bar in-house, where nobody knows what's going on. I worked there. I saw it happen. I didn't participate in it. And that's why I'm here today at 78 years of age to present to this court. This court cannot impose reciprocal discipline on a void ab initio order where the entity lacks subject matter jurisdiction. Now, this court can set up a disciplinary case against me and allow me to come in and defend those spurious charges. They brought no witnesses with them to testify against me, except one state bar investigator who testified to hearsay. They didn't bring in those lawyers they're talking about from Suffolk. They didn't bring in the judges. They didn't bring in, my clients came to testify for me. And the first thing the bar did was in 18, and she made a year mistake in her first remarks. Because in 18, they came after me saying I was impaired to practice law. They had no witnesses. They had no medical evidence. They could not prove it. They demanded 5 years of my medical records from every provider and told me I needed to go to independent psychiatric exam. That's what this bar does. That's a clandestine hearing. You cannot have the public there. The press can't be there. You can't even have your own court reporter there. It's behind locked doors. And when I wouldn't give them, of course, 5 years of medical records because of my client's confidentiality, my children's confidentiality, my other family members' confidentiality, my confidentiality, in violation of all HIPAA regulations you can think of and privacy laws, they suspended my right to practice for non-compliance. I couldn't appeal that order. You can't appeal a non-compliance order under this state bar disciplinary system. So I asked for a memorandum order. The bar refused to issue a memorandum order because I could have appealed that in 2018. This woman right here is the one who accused me of being impaired to practice law. Well, I'm not impaired to practice law. And this case is about affording the public and lawyers who are members of the public and who are respondents due process of law. It is about the entities that impose discipline under the bar system, the right only when they have the right for under subject matter jurisdiction, which they don't have because they're not judges, they're not courts. And this case is about 3909. Yes, that says the bar can enact procedures, not appoint judges or create courts. That's not procedure. 3910 says they can only investigate and report. Who do they report to? If you look at Consumers Union, which is 446 US 719, issued in 1980, 4 years after the bar created this illegal system, it says the state courts. That's who they're supposed to report to. They're supposed to report to the state courts. In Virginia, that can be any state court, believe it or not. It doesn't have to be a circuit court. So this is about due process. This is about subject matter jurisdiction. And if this court believes that that order was entered by a court in Virginia, a state court, then yeah, impose reciprocal discipline. If you think it was not entered by a state court and not entered by judges, then you can't impose reciprocal discipline. You can try me and I'll come willingly and defend myself against these spurious charges. They didn't let you know that nobody came from Suffolk to testify against me. Nobody came from Charles City to testify against me. What they did was put in hearsay records where the investigator for the state bar went out and copied the court files and presented the court files as 2,000 and some pages of evidence.
Ms. Daniel, you're a minute over your rebuttal time, so you're going to need to wrap it up. Is there any last thing you want to say?
I asked this court to refuse to impose reciprocal discipline, and if it thinks it's warranted, set a hearing for me to come in and be tried on the merits. Let me defend myself as I should have been defended before the bar in 2018, when the lawyer refused to challenge the bar's jurisdiction over impairment cases, because only circuit courts can declare people in Virginia impaired. Only circuit courts. The bar can't do that. They have no authority under the statutes to do that. And defend myself on the 2019 charges where my lawyer threw me under the bus. And he threw me under the bus, not only factually.
All right, Ms. Daniels,
but also,
your time is up, Ms. Daniels.
Thank you.
Thank you very much. All right, thank you both for your arguments here this morning. Ms. Schoenfeld, I want to thank you for taking on this court assignment. We typically would come down and greet counsel and the parties, but obviously because of COVID, we're not able to do that. But thank you again on behalf of the court for your arguments. We'll move on to our next case.
Thank you very much.
Thank
Yes,
you.
ma'am. Is it Nimni, sir? All right, sir, whenever you're ready.
Good morning, Your Honor, and may it please the court. There are three issues in front of this court today on appeal. First, whether the district court improperly dismissed Mr. Richardson's disability claims for damages at the motion to dismiss stage. Second, whether the district court improperly dismissed Mr. Richardson's disability claims for injunctive relief at the summary judgment stage. And third, whether the district court improperly dismissed Mr. Richardson's Arlupa claims also at the summary judgment stage. I'd like to start where the district court started, with Mr. Richardson's damages claims, which were dismissed at the motion to dismiss stage. At the motion to dismiss stage, the district court held that Mr. Richardson's damages claims under the ADA could not go forward because Title II of the ADA does not abrogate state sovereign immunity where there's no companion constitutional violation. That holding is flatly contradicted by the Supreme Court's precedent in United States versus Georgia and this court's precedent in Constant. The United States Supreme Court laid out in United States versus Georgia a three-part test to determine in the prison context whether state sovereign immunity was abrogated. First, there needs to be a showing of what behavior from the state violated the ADA. Second, there needs to be a determination by the district court of whether there is a companion constitutional violation, whether there was behavior that also violated the 14th Amendment. And then third, if there is no companion constitutional violation, the district court must then move on to step 3 and analyze whether, absent a companion constitutional violation, Title II of the ADA nevertheless abrogates state sovereign immunity in the prison context. The district court here did not move on to step 3, and for that reason alone, this court could reverse and remand. But
Counsel, if I could interrupt you there, I appreciate that that's the order you're going in, because that was the first, decision that is subject to appeal. But whether it's for money damages or injunctive relief, the basic liability facts are the same, aren't they? I mean, the basic claim is the same for disability.
I think that's more or less right, Your Honor. The disability claims relate to Mr. Richardson's degenerative eye condition and his hearing loss and the lack of provision of accommodation for both of those. There are facts as to his claims for injunctive relief since that got to summary judgment, and there haven't been as many facts developed as to how the facility might have violated the ADA retrospectively for his damages claims. But yes, Your Honor is correct that the genesis of the claims is more or less the same, although the facts temporally are a little bit different based on whether it's retrospective damages claims or a forward-looking injunctive claim.
So help me here. So let's assume, and this is just for, to get my bearing straight, not to resolve. Let's assume we found that the district court did not err in showing that Mr. Richardson did not establish a substantial burden on his religious activities. Would that finding apply as well to the money damages claim?
Well, Your Honor, Mr. Richardson, I don't believe on appeal has a money damages claim for the Arlupa violations. He's solely seeking injunctive relief for his religious liberty.
I'm sorry, I mixed them up. I'm sorry. Yeah,
but as to the ADA injunctive versus damages question,
right.
I think if this court were to hold that Mr. Richardson didn't establish a valid claim for injunctive relief on his ADA claims, you would still have to send it back to the district court to answer the question of whether Title II abrogates state sovereign immunity, so that Mr. Richardson could develop facts, seek discovery as to the damages claims. He was only able to put forth facts and seek discovery as to whether the facility was ongoingly violating his ADA rights, but he didn't have the opportunity to establish facts. He only had the opportunity to plead that they retrospectively violated his rights under the ADA and that he was entitled to damages. He wasn't able to establish those facts because the district court improperly dismissed.
To follow up on that, if we were to find that his rights were not violated at all under the ADA, there would be no need to remand.
Yeah,
correct?
On the ADA questions, both damages and injunctive relief, that's correct. There would still be the
RLUIPA. Yes. And so on the ADA claim, what is his primary ADA complaint? What is the denial that he's primarily complaining about? I can't really grab hold of what that might be.
In Mr. Richardson's particularized complaint, which is at JA 11 to 60, and also in his declarations that are attached to his motion for appointment of new counsel, and his additional documents that he filed around the time of summary judgment, he points to two primary disability claims. He is a qualified person with a disability because he both has a degenerative hearing condition and a degenerative eye condition that has rendered him legally deaf and blind, and progressively so. His eyes get worse and his hearing gets worse. And he has alleged and put forth some facts to demonstrate that he has been denied access to program services or activities in the facility, including communication, library services, emergency services. Now, my friend on the other side has put forth facts as to how they've attempted to accommodate those disabilities over time. And we have no quarrel with the idea that they have sometimes accommodated Mr. Richardson, but his damages claims are premised on the idea that there were times where he was not accommodated and therefore he was denied program services or activities. And his injunctive claims are premised on the idea that he currently is being denied reasonable accommodations and therefore is denied access to program services or activities. And the district.
But he has to have been denied if he was because of, or as a motivating factor because of his disability. Where is that in the record that he was denied accommodations and his disability was a motivating factor for that?
Well, you're under the ADA, when there is a denial, when a plaintiff makes a prima facie showing that they have a disability and that they cannot access program services or activities, the denial of a reasonable accommodation qualifies under the ADA as a denial because of disability or the motivating factor as a result of disability. You could imagine, for example, a quintessential ADA claim where you had a plaintiff in a wheelchair and there were steps in a facility and they couldn't get up those steps. And they were seeking injunctive relief for the facility to build a ramp. It would be very difficult to say, well, you're being denied program services or activities, motivated by your disability. But in fact, it is because of their disability. They cannot get up the steps or they can't have meaningful access to program services or activities without the accommodation. And the same is true for Mr. Richardson. He's asking for very simple accommodations. An increased level of prescriptive lenses, which the facility has provided some prescriptive lenses in the past, and more regular ASL interpretation, particularly when it comes to court documents and engaging with the court process.
Counsel, that last comment you made is the way I kind of read what he filed in response to the summary judgment motion. And it seems to me the strong flavor of it is assistance in the prosecution of this case in legal matters. And I wonder if that's an ADA claim as much as it is a right to courts or right to access to courts claim, which he initially filed, but which was dismissed and which dismissal hasn't been appealed. So I just wonder, even accepting what he says in his filings, if they relate to access to courts rather than traditional programs and activities, is that an ADA issue?
I think it is, Your Honor. You're correct that he pled both, and I think he might have been able to proceed under his access to court claims. But here, I think it's best to think of his access to court claims as access to the services in the prison that would allow him to engage with the legal process. So the library, the different computer terminals, different written services, those are all services provided to non-disabled people inside the prisons. And even though the result is that he's denied access to the court, the reason that he's denied is because of his disability and the lack of accommodations.
So to follow up on that, does the plaintiff have to make a showing of how the lack of those services actually denied access to the courts? Because it seems to me, on the face of this record, he's doing a pretty good job of accessing the courts.
Well, two responses, Your Honor. As an initial matter, he doesn't need to show that he was denied access to the courts. He only needs to show under the ADA that he was denied access to program services or activities in the facility. For example, the ability to read in the library, and that the facility denied him reasonable accommodations. But I also think that the pieces of the record that show him prosecuting his case can be read in a couple of different ways. Mr. Richardson has put forward in the filings surrounding summary judgment that he often has other prisoners assist him with the filings, and there are a variety of different ways he attempts to cope with his disability. And the standard under the ADA really isn't whether he can access the services, it's whether he has meaningful access to the services. I think Tennessee versus Lane is instructive on that. The plaintiffs in Tennessee versus Lane, which was an access to the courts issue, were able to access the court by crawling up the stairs, but that's not meaningful access. And here what Mr. Richardson seeks is meaningful access. If I could turn just briefly back to the motion to dismiss question as far as whether Title II abrogates state sovereign immunity, I would just urge this court to follow the precedent that Title II does abrogate state sovereign immunity in the prison context, regardless of whether there's a companion constitutional violation. In Constantine, you held that a student who had a migraine and was seeking extra time on a test had a valid ADA claim for damages because of the general history of discrimination against people with disabilities in education and because of the proportionality of a damages remedy to the harm at issue there. The same, if not more, is true in the prison context. Schools provide students with housing, food, medical services. Prisons too provide their inmates with housing, food, and medical services. And an ADA damages remedy is congruent with the past history of discrimination against disabled prisoners, and that's in the congressional record for the passage of the ADA. And it's also proportional in the same way that it was proportional for the student in Constantine.
Do you want to say anything about your RLUIPA claim?
Thank you, Your Honor. If I could just turn to the RLUIPA claim, there's a couple of different issues. The district court raised, held that there was no substantial burden on Mr. Richardson's sincerely held religious beliefs. He has a sincerely held religious belief that he pled in his particularized complaint, and that the defendants acknowledge that he has the sincerely held religious belief to wear a head covering at all times. He was denied the ability to wear a head covering at all times. That on its face is a substantial burden on his religious activity. And I think this court can look to cases in this circuit. It can also look to Ali versus Stevens in the Fifth Circuit, where the facility had the exact same rule. You cannot wear a head covering in certain places in the facility. And there, the Fifth Circuit said, well, we have to do the balancing test. We have to see what the compelling governmental interest is. Here, it's a security interest, the same that defendants offer. And we have to determine whether that's the least restrictive means possible.
So counsel, if I could interrupt, I'm sorry. I'm familiar with the cases and you've cited those. What the district court said was not that he didn't have a sincerely held belief, but that he hasn't put forth any evidence of a substantial burden. And if you assume substantial burden, then you get to I think those cases. But I think there's a first step of whether or not he has done that. And it seems like in your brief, you're kind of saying it's just obvious. And I'm just trying to get a sense of that. Is there something in the record where he has met the substantial burden? And first of all, is there something where he has done more than allege it in his complaint?
No, Your Honor. There's nothing in the record that there's nothing in the record where he specifically has put forth facts. There is a declaration. There is a declaration by one of defendants that recognizes that he has the sincerely held religious belief to wear a head covering at all times. But I do think that it is obvious. I think if someone's religious belief is I have to wear a head covering at all times, and there's a rule that says you cannot do that, then there's no other way to read that than a substantial burden on his religious beliefs. I think if he had a different religious belief that was I have to wear a head covering in certain times or in certain places, that might be different. Or if the government's rule was more narrowly tailored and less restrictive, it was just searching head coverings, then this would be a different case. But his belief is I have to wear it at all times. And their rule was that he cannot wear it in certain locations. And if I could just briefly address the government's mootness argument, the district court held that this matter was not moot, and we agree with that. It's not moot because the defendants have made no showing that they won't simply just return back to the policy. And that's really the standard here of whether they've acknowledged the prior policy was unlawful and whether they will return to it in the future. If Mr. Richardson's claim here is mooted out, the defendants could immediately at the drop of a hat just switch back to their former policy because there's been no acknowledgement as to illegality. So that, so on that claim alone, this case should also move forward and be reversed and remanded to the district court. I see my time is running out if you have any other questions.
Thank you very much.
Good morning, Your Honors. May it please the court. I'm Kevin Gallagher, Deputy Solicitor General of the Commonwealth of Virginia, representing Appalese. With me today is Annie Chang, Assistant Solicitor General. Although Mr. Richardson lodged almost a dozen complaints about 6 defendants related to his time at 2 different correctional facilities, this case has been whittled down to 3 issues before the court today. The district court was correct in its rulings on all 3 and should be affirmed. First, the district court correctly granted summary judgment on Mr. Richardson's RLUIPA claim. As the undisputed record evidence shows, in October 2020, the Department of Corrections changed its policy to allow inmates to wear head coverings anywhere inside their facility. That policy remains in place 2 years later, meaning that Mr. Richardson's RLUIPA claim falls within both RLUIPA's safe harbor provision and is moot. And in any event, although Mr. Richardson alleged generally that he had a sincerely held religious belief regarding a head covering, he put no evidence in the record about how any policy at his facility imposed a substantial burden on his religious exercise.
Counsel, on that point, I think there's a fair argument to that, but you didn't move for summary judgment on that basis. And so I'm a little torn, the district court certainly ruled on that basis, even though the defendants hadn't moved on that basis. So there was really no facts put forth in support of the motion for judgment or even an argument on regarding summary judgment about substantial burden. And Rule 59 or 56F says that certainly a district court can do that, but only is supposed to have notice and an opportunity to respond. So is Mr. Richardson in a bit of a bind when you and now that wasn't the basis of appeal. So, but still back at the trial court level, it seems like that puts him in a bit of a bind. What's your response to that?
I have a few responses to that, Your Honor. I think first of all, the district court did rule on that ground, and as you've said, and certainly is clear from this court's case law, this court can affirm on any ground supported by the record. So that is certainly supported by the record, in that the district court ruled on that way. Number two is the burden is on Mr. Richardson in proving his claim or in getting past summary judgment of his claim to establish a substantial burden. So he had ample opportunity to put evidence in the record that this was a substantial burden. And I want to be clear about our position here. We are not challenging the sincerity of the religious belief. We conceded that at the motion to dismiss stage, and we also conceded it in the summary judgment briefing. But it is his burden to show that that sincerely held religious belief, which is articulated in the complaint as a belief generally about head coverings, that there is a policy that VDOC and the other appellees put into place that actually substantially burdens.
Yeah, that's his burden for sure. I'm not disagreeing, but if we're in a negligence case and you move for summary judgment on breach of duty and a district, it wouldn't be normal or expected for a plaintiff to put forth evidence of damages in summary judgment. So obviously at trial, you got to meet all the elements of your case. And it seems like that's what we have here.
I understand your. I think first of all, the main grounds that the VDOC and the other defendants moved for summary judgment on is mootness, which I think also sort of goes to maybe why certain arguments were made or not made, because obviously that's an Article 3 issue. If this court were to rule on that ground, there would be no need to get to the sort of next level question of the substantial burden. But I keep going back to it was his burden in order to move forward with his claim to show substantial burden. And there's just the case law is pretty clear. And my friend on the other side has been amply put that in his briefing, that it's a decently low bar. I mean, there are cases that he cites where it's a simple affidavit saying, I have a religious belief to wear my kufi at all times. I mean, that often gets past the bar. And so Mr. Richardson, and we'll talk about access to the courts, but I mean, he was submitting filings throughout the course of this proceeding, including the two affidavits that are at issue for summary judgment stage. And in that process, he said nothing about his head covering. He says things about the ADA claims, but he does not say anything about the policies in place. All that evidence comes from our side. And so the district court, I think.
Mr. Gallagher, I'm sorry. So you're not conceding that he has a legitimate, sincere belief that he has to wear his headgear at all times?
I want to be very clear about what our position is. Mr. Richardson, in his complaint, said that he has a sincerely held religious belief to wear a head covering to honor the creed. People have different sincerely held religious beliefs about when and where and how much they need to wear their head covering. And so in the cases that the other side cites, there are people who they're okay if they only wear it in religious observances. or only in certain areas of the facility, or they need to wear it at all times. We just don't know based on the record evidence. All we have is a simple allegation, not proof or not evidence, an allegation that he has a sincerely held religious belief generally about head covering. We don't know in what locations he feels he needs to wear it, at what times. We have in the brief the other side saying that it is clear that he meant at all times, but it is certainly not in the record that it is at all times.
So if for whatever reason, the record would show otherwise, and there's competent evidence that his religious beliefs require that he wear the headgear at all times, you would concede that that's a violation of Arlupa?
We would say that that is very likely enough evidence to get past the substantial burden element. There are things that both sides need to show for a RLUIPA claim to go forward. The plaintiff needs to show a sincerely held religious belief, conceded that, and then a substantial burden, usually a low evidentiary bar, but still an evidentiary bar. Then it would flip to the other side for defendants to show compelling government interest, narrow tailored means, and things of that nature. We never got to that stage because the plaintiff didn't meet the bar to show the substantial burden. So I would say if there were evidence in the record, which there's not, but if there were evidence in the record showing a substantial burden, then that would not necessarily establish the RLUIPA claim generally, but it would get to that next stage of flipping the burden to the defendants.
Okay.
Right, and
Go
I'm
ahead.
sorry. And as to that, on mootness, what is to keep the Bureau of Prisons from simply reinstating the ban on head coverings after this litigation is over?
The ability to change a policy certainly exists in the discretion of the Virginia Department of Corrections. That's in the Porter case, that's in the Wall case. However, in those cases, the Department of Corrections and the appellees or defendants in those cases were not willing to not go back to the policy. Here, the Virginia Department of Corrections has no intention to go back to the previous policy. And so that puts us in.
Currently, they have no intention. You standing here today, you're saying they have no intention, but they still could.
They retain the discretion to.
So how is it moot?
It is moot for two reasons. So there's a Article 3 mootness, which first of all, New York State Rifle, which came out after this court's decisions in Porter and Wall, said, as long as the plaintiff has gotten the precise relief they've asked for, then the case is moot. My friend on the other side would certainly say, well, there's still a voluntary cessation issue. And we would say that this case is different from Porter and Wall because of the intention to not return, the fact that 2 years have passed and the policy remains the same. And I think generally we see the VDOC being more.
Well, if the administration of the Bureau of Prisons changes, so could the policy.
It certainly remains in their discretion to change generally, but as I've said, and would reiterate, the Department of Corrections currently does not intend to go forward with that or to change.
Right, the key word being currently.
That's correct, and that's why then we have the separate argument of the RLUIPA safe harbor. So RLUIPA has a provision in 2000 CC-3E that says that by changing the policy or practice that results in a substantial burden, the government can avoid prospective injunctive relief. And so we have a situation in which the government did the exact thing that RLUIPA intends to incentivize them to do. A potential substantial burden was identified through the claim that Mr. Richardson and maybe other prisoners have brought. And VDOC took that into consideration, changed the policy, and the RLUIPA safe harbor provision says that they should be able to avoid the injunctive relief that Mr. Richardson now seeks, because that is exactly how the statute is laid out for them to do. And I would point this court to two cases. One is a Seventh Circuit case at 342 F3rd 752 that applies that safe harbor provision in a zoning case, but obviously RLUIPA covers both. And then an unpublished but 10th Circuit case, 528 Fed Appendix 838. And in both of those cases, the safe harbor provision was applied in sort of similar circumstances where even if there's a question about mootness and voluntary cessation, And even if this court thinks that for Article 3 purposes, that mootness is not applicable, there is a separate analysis for the RLUIPA safe harbor, which would not include that same voluntary cessation.
Mr. Gallagher, I know you want to get to your ADA claim, but let me just go back to this issue of substantial burden for a moment. I was just going through the record, and you say that Mr. Richardson never presented evidence to show that he had a sincerely held belief that he needed to wear his religious headgear at all times in all places, but your own client's affidavit at JA 130, and this is an affidavit, let me see. Hold on a second. Signed by a T. Williams. This is a JA 130. Says, I understand that inmate Richardson claims that it is his sincere belief that he wear his kufi, a religious head covering in all areas of Deerfield. And so haven't you conceded that that is essentially his belief that he has to wear his headgear everywhere?
I understand that that is what the affidavit says. However, I would point back to the fact that it is the burden of the plaintiff.
Well, not if the other side concedes the point.
But I think that the affidavit sort of is a separate issue about whether that point was conceded. It certainly was not conceded in any brief, and the district court did not consider it to be conceded. And so I would say that, again, with the district court ruling on that ground, it is certainly a live controversy about whether there's any evidence in the record. And I would repeat that the plaintiff did not put any, Mr. Richardson did not put any evidence in the record about that element.
All right.
And I will now questions about the return to the ADA claims. So the district court correctly granted summary judgment on Mr. Richardson's ADA and Rehabilitation Act claims, and for ease of reference, I'm just going to refer to them as the ADA claims because it's a similar analysis. Mr. Richardson contends that the appellees prevented him from having meaningful access to the prison's law library and the courts, but the undisputed record evidence shows the opposite. So appellees, first of all, bent over backward to accommodate Mr. Richardson's access to the law library, even granting him computer access when it would normally not do so for inmates. And Mr. Richardson claims that appellees prevented him from accessing the courts, but the record here belies that, where he filed over a dozen filings between the time where he says that he was not granted access to a personal caregiver and also to a certain time with ASL interpreters.
Counsel, can I want to ask kind of a question that's different than the evidence in the record about whether there's been some discrimination under the act. Mr. Richardson says that because of the ruling on the motion to dismiss, he has been unable to develop evidence on the money damages claim. I'd asked if the record shows an absence of a claim, at least on the injunctive claim, that resolves effectively all the ADA claims. What's your position on that? I mean, assume I agree with you, or we agree with you on the accommodations or the failure to provide access. Does that resolve the money damages claim too?
I think it does, Your Honor. So for a couple of reasons. First of all, Mr. Richardson put in the two affidavits into the record, and they don't really distinguish between time at Deerfield and time at the other correctional facility. The district court had already dismissed claims about the previous time at the first facility, but Mr. Richardson was still entering evidence. He was operating pro se, but he was certainly entering evidence about his time generally in correctional facilities. And so I think there's more than enough record evidence about the both going forward prospective relief claim, but then also damages claim. And I would say that more generally, the ADA and Rehabilitation Act claims rest on this denial of access to the courts. And I think that as a matter of law, there's no denial of access to courts here, because the record evidence, regardless of what was happening to Mr. Richardson on the ground, either before or after a certain time, throughout the course of this litigation, he was able to file things all over the record. The court in the district court had been asked to appoint him counsel because he was saying, I'm not able to do this case without counsel. The court said very clearly, the record belies that. You are filing more than enough on the record. You can do this case by yourself. And so regardless of all the different aspects that Mr. Richardson would bring up, and he has sort of a litany of claims or factual allegations in the complaint that weren't necessarily put into the record at summary judgment. None of those allegations would establish that he was not given access to the courts, that he was denied meaningful access to the courts. And so I think regardless of what the evidence would have shown, and certainly what the evidence did show, there was no ADA violation as a matter of law. And I want to talk about the two claims that are actually in the record, because there are things that are, having ASL interpreters, American Sign Language interpreters in medical settings. There's no evidence in Mr. Richardson's affidavits about those. So the only two things that are actually in the record are that he was denied a caregiver in order to help him use the computer system, and that he was denied more than 5 hours a week of ASL interpreters. I would point the court to his second affidavit, which is found in the record at 209 to 13. Those two sets of claims directly go to this area, or this idea of access to the courts. He's saying that because I didn't have someone to help me navigate the computer, and because I didn't have more time with ASL interpreters, I was not able to put my filings in court. But again, the record certainly belies that. He had, from the time that he said that he was not given that personal caregiver in August of 2020 until the case ended, he filed almost a dozen or over a dozen filings on the docket. And briefly, because I see my time is coming to a close here, I do want to talk about the sovereign immunity issue. And so I think there are, as my friend on the other side has identified, 3 steps to the analysis in the United States versus Georgia. You would look at whether there is conduct that's alleged to have violated Title II. And at the summary, or at the motion to dismiss stage, the court did not dismiss a claim of the Title II claim. And so we would say that that element has been met. The second element is then looking at whether there is conduct that actually violates the 14th Amendment. Mr. Richardson contends that because he labeled a claim as an 8th Amendment claim in his complaint, that he has met that problem, that he can go forward sort of under the core holding of the United States versus Georgia, which is that if conduct actually violates the 14th Amendment, Title II is abrogated. He would say that all he has to do is put some factual allegations in the complaint and then slap a constitutional label to it, and that would get you past that bar. That is not the court's ruling in the United States v. Georgia. And I would point this court to Toledo v. Sanchez, which is at 454 F3rd 24 in the First Circuit, to sort of see how that analysis works, where the Title II claim and then what the allegations are for constitutional claims, how those interact. Then we would get to the third step, if for whatever reason so if you agree with us about the nothing actually pled that actually violates the 14th Amendment, then we get to the third step, which is, well, is Title II, is abrogation under Title II nevertheless valid for this class of conduct? Mr. Richardson believes that because of this court's holding in Constantine, that answers the question. However, the Supreme Court has told the lower courts to analyze the class of conduct at issue. And so the Constantine case is very particularly and very narrowly in the education context, which courts around the country have looked at and said that Title II does abrogate sovereign immunity in the education context.
But the district court didn't get to that third step. So if we were to agree with you that Constantine's education, this is different, and it's in, you have the argument it's incongruent, we'd be doing that in the first instance because we don't have at least a decision below on that, right?
I actually don't think that's true, Your Honor. I think that in the court's holding, the court laid out the analysis in United States versus Georgia, cited the court's opinion, the Eastern District of Virginia opinion in Chase v. Basketball.
So you think the citation of Chase is enough to say that that the district court made a finding on congruence?
I see my time's up. May I answer your question?
Absolutely.
Thank you. Your Honor, I think that in Chase, it was not just a citation, but it was a quotation saying that in the context of Title II, that you can only show abrogation of sovereign immunity in the prison context because of if this conduct actually violates the 14th Amendment. And the holding in Chase v. Basketball is after a long analysis that the same Judge Hudson did about the prison context and why sovereign immunity would not be abrogated in that context. And so, I mean, maybe on some level it's an incorporation by reference, but it is certainly referencing the main holding of that case, which after an analysis of this issue under the third prong, the City of Bernie test, after that analysis coming to the conclusion that it is not nevertheless valid in the prison context for sovereign immunity to be abrogated. So I do not think that this court would be doing new work here. It would merely be affirming the district court on the grounds supported by the record.
What is it about if we agree with, well, I know you don't want us to get to the third step and look at Constantine, but what is it about the prison context that makes Constantine not applicable to this case?
I think there's two main arguments as to why that's the case. So in the prison context, there are a lot of services that are offered just as a means of grace. That's the phrase that's used in Chase v. Basketball. So you think of TV access, computer access, things of that nature. The court in Chase makes the point that that would basically open up prison systems which are already resource constrained. They would open up prison systems to liability for damages based on either not giving or limiting access to things like that have no bearing toward any sort of constitutional violation. One of the rights that one of the primary rights that we look at to see whether it's congruent and proportional to the constitutional right at issue is the Eighth Amendment. And the Eighth Amendment has such a high bar that things down the line, like not granting access to an ASL interpreter in a medical setting, is so far afield from deliberate indifference to medical issues that there's not congruence and proportionality to it. And then secondly, generally, state prison systems are given a significant amount of deference and leeway in the court system, and I would by the courts. And I would point this court to Chase opinion again, which sort of has a litany of cites on that point. Generally, as opposed to the education context, the prison context is a situation in which the courts will give a decent amount of deference to the state correctional systems because they are much more in tune with the situation on the ground, and also generally there are they have more ability to sort of oversee their internal systems. Unless there are any further questions, we would ask the court to affirm the district.
All right, thank you.
Hello again, Your Honors. I'd just like to make a few points on the ADA claims and then a few points to clean up the discussion of the Arlupa claim. I want to address Judge Quattlebaum's question that you asked both me and my friend on the other side as far as whether resolution of the injunctive claims would address the ADA claims. I heard my friend on the other side say, as he must, that the Title II claim at the motion to dismiss, the district court did not dismiss the Title II claim by saying that the elements of the claim were not met. And for that reason alone, the Title II claim for damages should be remanded to determine whether or not there can be evidence to fully prove up that claim. The district court dismissed the claim for the sovereign immunity reasons, not for substantive reasons. And it would be improper to import the evidence that from summary judgment to then inform the motion to dismiss, which is on a different issue and different temporally. Mr. Richardson would be able to prove up more clearly when and how the facility denied him access to services retrospectively. And that's a different thing to prove than whether they're actually denying him services prospectively. As far as the citation to Chase versus Baskerville, I would just point this court to two things. First, our reply brief that notes that Chase versus Baskerville rests on shaky foundations. And Chase cited Miller from the 11th Circuit, which was a pre-Georgia case. Miller was then abrogated by the 11th Circuit post-Georgia, understanding that its holding there was not correct. And so Chase is on shaky foundations to begin with. But other courts in this circuit, in the districts of Virginia, have held that Title II of the ADA does abrogate state sovereign immunity in the pretrial context. And there's no meaningful distinction for the purposes of ADA between the pretrial context and the post-conviction context. As to my friend's concerns about prison discretion, those discretionary concerns come in during the period of litigation, not on the question of whether there should even be a claim at all. In fact, prison is probably the ideal place to put an ADA claim. Prisons are already subject to Title II for injunctive relief, which often entails much more strenuous activities on part of the prison, changes in services, changes in architecture, changes in personnel. So damages doesn't really open up new liability. And there would still be the safeguards of the PLRA. Prisoners would still have to prove that they had exhausted the prison administration grievance process. They would still have to be screened out on a 1915A screening order. So all of these safeguards make the prison context an ideal place for the ADA.
Can I ask, before we turn to our LUPA, I asked this question earlier and Mr. Gallagher, I guess, responded to it. And this is the question of the fact that the ADA claim seems to bleed over into a right of access to the courts claim. And Mr. Gallagher made the point, and maybe there's a factual dispute about this, that even without the interpreter services and the caregiver services, that your client, Mr. Richardson, continued to file a flurry, as he put it, of documents in the docket, suggesting that in fact there was no prejudice with respect to the fact that he wasn't given the services. So, and I know your point is that the ADA requires meaningful access. You gave the example of a plaintiff being required to climb up or crawl up the stairs of a courthouse, but that's not this case, right? It's if in fact he continued unabated to file legal documents, doesn't that suggest that there really isn't an ADA claim?
Two responses, Your Honor. First, just to clarify, I think there's some confusion on this, and there's good reason for the confusion, but the service that he's being denied is not necessarily access to the courts, but access to the legal library, access to the services that the prison provides. Obviously, the prison doesn't necessarily provide access to the courts in and of itself, but provides all the mechanisms to access the courts. And as to whether he's been provided meaningful access, there is evidence in the record at JA 209 that Mr. Richardson has to ask other inmates for assistance, that he is able to file some court documents, but there's record evidence that it takes him 600, 800, sometimes 1,000 hours to go through court documents. Much longer, much more strenuous than a non-disabled prisoner, or if he were given accommodations. And that's what meaningful access means. Of course, this isn't as extreme as the plaintiffs in Lane who have to crawl up the steps, but it is still a question of whether there's meaningful access.
I really have some questions about RLUIPA if you've finished with that answer before you ran out of time. What is your response to Mr. Gallagher's argument that appellant hasn't met his substantial burden because there's no evidence in the record, he says, that appellant was his sincerely held religious belief required him to wear the head covering at all times?
May I answer?
Yes.
Well, there's two places I think that this court should look. First, this court should look at Mr. Richardson's particularized complaint, which not only says that he was denied, that he has a sincerely held religious belief to wear a head covering in the facility, but then in the next paragraph says what the facility was doing to deny that. But then as far as record evidence, I would point to what Judge Diaz pointed to, which is their own statement that Mr. Williams understands that Richardson claims it is sincerely held religious belief to wear a kufi, a religious head covering, in all areas of the facility. I think it flows logically that if it is your religious belief to wear a head covering in all areas, and there's a rule that he has pointed to in his particularized complaint that prevents him from wearing it in all areas, that means that his religious beliefs are substantially burdened. And all areas can include, as we mentioned in the brief, areas like the visitation area, areas like the dining hall.
And then what's your response to his safe harbor argument on mootness?
As to his safe harbor argument on mootness, I think the safe harbor provision needs to be read in conjunction with the mootness standard. And so it's true that if the facility were to change the policy permanently going forward, that would also apply to the safe harbor provisions for our LUPA. But the mootness concerns are still there, that they could just switch the policy back at any point. And I think this court's analysis in Wall demonstrates why that's such a danger, especially when it's difficult for pro se prison litigants to even file claims. The prison could just switch back and forth, and then the prisoner would have to go through the whole process, exhausting the grievance process and going through all these filings.
So why would you need, why would you need a safe harbor provision in that case if the prison made a commitment that they would not go forward, ever change the policy? What's the point of the safe harbor?
I don't, Your Honor, I don't see anything in the record, and perhaps my friend on the other side could point to it, demonstrating that the prison had made the commitment.
No, I agree with you. I don't think they did, but that his point is that prospectively, with respect to injunctive relief, that's the whole purpose of the safe harbor policy, and then perhaps your client isn't entitled. Any claim for damages might not be moot if there is such a claim under our LUPA, but going forward, the safe harbor provision prevents a court from entering injunctive relief.
We just don't read the safe harbor provision provision as expanding that far beyond and limiting this court and Supreme Court's mootness doctrine in that way.
Okay. All right. Thank you very much, counsel. Thank you both for your arguments here today. We appreciate the arguments presented. We typically would come down and engage you, but obviously we can't do that under the circumstances. But again, thanks very much for being here. Thank you. You okay going? You okay going on?
I'm fine. I'm glad to do what
Somebody go out and get counsel.
They're
Oh, they're remote. I'm sorry. Should have read my document. All right. Our third case is Song versus Garland. And Mr. Eccles.
Good morning, Your Honor.
Whenever you're ready.
I'm ready to begin, Your Honor. Good morning, Your Honors. My name is Eli Eccles. I represent the the petitioner here, Sathan Song. Ms. Song is an applicant for admission, an applicant for adjustment of status. And it's our argument today, Your Honor, that the Board of Immigration Appeals decision in this case is not deserving of deference under matter of Chevron because it's represents an abuse of discretion. It's an unreasonable decision. And Your Honor, this case is not about whether an affidavit of support applies. As the government has noted in their brief, we are not attacking sort of the overall statutory scheme here, but there is a silence in the statute about whether, about how and whether a petitioner can withdraw their affidavit of support. And it's our argument that in this silence, the administrative agency here should be reasonable in the way that it interprets the regulations
Right.
to apply.
And so how is it that they were unreasonable here? What makes their decision unreasonable in this case?
Yes, thank you, Your Honor. Well, we would point to matter of CSA. The court here found, and the board found, that the petitioner here is eligible to adjust her status under the terms of matter of CSA, despite the fact that she's been divorced by the petitioner. That whole case stands for the idea that there's some gaps in relation to the fiance petition and the adjustment of status scheme and the immigrant versus non-immigrant visa scheme. That case said that the gap should nevertheless be construed to allow fiancés to continue to adjust status, even though they cannot satisfy the literal terms of the statute. That's the background here. Now, here, the petitioner divorced, the U.S. citizen petitioner divorced Ms. Song, and the board found she was still eligible to adjust. Where it went unreasonable was when it sort of undid everything CSA stands for by allowing the petitioner to essentially have a veto power, a unilateral veto over the process by withdrawing the affidavit of support.
Counsel, if I could interrupt, I appreciate I think I understand your argument in response to Judge Thacker that CSA is kind of the basis. If the board is going to relax 1255D, why not relax the regs on withdrawal of affidavits? But isn't it the case that, first of all, that the regs on withdrawal of affidavits, by their plain terms, would permit the withdrawal here? I mean, I know you have an objection to it, but just reading the black and white of the regs would allow the petitioner, Mr. Singh, I think, to have withdrawn the affidavit. Do you agree with me on that?
Yeah, I think I have to agree with you on that. If we're under the reg that explicitly applies to adjustment of status.
Okay. So if I could follow up, go ahead and finish. I asked you a question. I want to let you finish, but I have a follow up.
Go ahead with your follow up, Your Honor.
So if the regs say that, then as you note, they have to be unreasonable. And why is it not unreasonable for the agency to have different rules for fiance visas and petitioners than it does for spouses? There was a lot of concern about marriage fraud in the immigration context. Whether you agree with it or not, whether it's perfectly consistent with CSA or not, why is that not within the realm of reason?
Well, Your Honor, both the IJ and the BIA here appear to have taken the position that as administrative agencies, they can't really make a ruling on the validity of the regulations themselves. So I don't think they really took this head on. And I think the unreasonableness lies in the application of the regs, not in the regs themselves. So this decision, it's not the regs that don't deserve the Chevron deference, but it's this decision that doesn't deserve deference, Your Honor, because the court here failed to do what CSA did, which is take into consideration the special circumstances of a fiance who's uprooted themselves and moved to the United States in reliance on this marriage working and in reliance on the petitioner's good faith. The regulation, there is a regulation that exists that would protect this reliance, and it's the next section of that regulation about the withdrawal of the petition, of the affidavit of support, Your Honor. And so all we're saying is that it is unreasonable for the court and the BIA here to prevent the applicant, the petitioner here, from presenting a substitute sponsor, where the regs do contemplate such a thing in many different areas. If they simply declined to give the withdrawal of the affidavit of support legal force, because again, the petitioner did file it, and all the regs require to have a joint sponsor is if it's been filed. All they have to do is not give the written withdrawal legal force, and she'd be able to present a joint sponsor that would cure the public charge ground of inadmissibility. It's not that we're asking for a new exception or anybody to edit a regulation. We're not asking for a court to rewrite anything, but simply to apply in this very similar legal fiction as applied in CSA, apply the immigrant visa regulation rather than the adjustment of status regulation. And the reason we think it's unreasonable not to is because in this particular part of the process, the respondent much more resembles the immigrant than the person who's already here, in that she's only here based on all that reliance.
Mr. Eccles, so in response to Judge Quattlebaum's question, it sounds like you are asking or suggesting that the BIA should have ignored the regulation, because I think, as you have to concede, that the issue is that the regulations do provide for a substitute or joint sponsor in the context of an immigrant visa, but not in this context when you're dealing with a non-immigrant visa. Now, you may think that's patently unreasonable, but that would require both the BIA and this court to ignore the regulation.
Well, I don't think the distinction here is between immigrant and a non-immigrant. The distinction here is between whether it's an adjustment of status, pure, normal, average adjustment of status context, or whether it's an immigrant visa context. Because CSA has already said that this should be treated as an immigrant visa and not as a non-immigrant visa. So that part's settled. And I'm not so much asking the court to ignore the regulation.
You're not alone in this, right? The USCIS questions and answers support you, correct?
Well, Your Honor.
That the BIA applied the wrong regulation.
So, Your Honor, that's what I thought when I read those questions and answers, and that's what I thought when I filed that motion to reopen. But upon reading them further, I think that actually much of what looks like it supports us is just a restatement of a question. And the paragraphs that come after that are actually USCIS saying that they're not going to do it that way. So unfortunately, I don't actually think those questions and answers help me, which I didn't realize until after I had filed the motion, after the motion open had been denied, in fact.
Okay,
That's why
I thought I was trying to help you as well.
Yes, Your Honor, I appreciate that.
I guess
Your
you
Honor.
can't be helped.
Well, and Your Honor, I
Go
think
right ahead.
I think this court can, I think respectfully, I think this court can help the petitioner by declining to defer to this case on the basis of the fact that it's not that we're asking them to ignore a regulation. We're asking that the board be told that they should have applied the second part of the regulation, the part that applies to the immigrant visas, rather than the part
And
that
that's
applies.
based on CSE? Because CSE doesn't talk about admissibility or inadmissibility.
Correct. CSE repeatedly states that as long as the applicant remains admissible, then they're eligible to adjust. And so really, CSE didn't take on this issue, partly because in CSE, the petitioner did not withdraw the affidavit of support. And that's part of what we're arguing here, is that the danger here is to, if you're going to open the door with CSE and permit this person a chance to still adjust based on all the equities involved in being a fiance and having relied on the marriage and moved over here, it's contrary to that whole effort to then give the petitioner a unilateral veto by allowing the petitioner to withdraw the affidavit of support. And there's no remedy to that. Unless there's abuse or the petitioner is dead, there's no remedy to the petitioner withdrawing the application, when the whole purpose of CSE is to provide them still with a path for
You mentioned abuse.
status.
Was there any indication in the record here that petitioner was a victim of domestic violence?
No, Your Honor. No, Your Honor. There isn't.
Okay.
I would never wish anybody to be a victim of domestic violence, and so I'm glad that there wasn't. But it leaves my client is still just as vulnerable to a predatory kind of behavior by a U.S. citizen spouse as someone who is a victim of abuse, because here Mr. Sang withdrew the affidavit of support and there was no remedy. So while they courted and loved each other, and she relied on that and came over and they married, some marriages fall apart. And here we have a situation where this policy, by allowing a K-1 petitioner to withdraw an affidavit of support, you're essentially exposing the non-citizen to a form of abuse, and it also it empowers bad faith actors more than it does good faith actors. If in a bad faith situation where there is actual marriage fraud going on, they don't need to worry about withdrawing an affidavit of support that's already baked into whatever conspiracy they have going on. It's really only in situations of a good faith marriage where, after it falls apart, the petitioner has an emotional reaction to the situation. It's only in those circumstances where the petitioner would care to withdraw the affidavit of support.
Mr. Eccles, you made the point, and I do stand corrected about the distinction I made earlier, is that the regulations do make a distinction with respect to immigrant and non-immigrant visas in the context of withdrawal, right, of the affidavit of support.
Yes, sir.
And you also discussed CSE, and you indicated that the court there, or the BIA indicated that divorce by itself does not necessarily prevent adjustment of status, because as in CSE, the petitioner there, the sponsor, did not withdraw the affidavit. And I think the BIA in this case made that point, that in theory, this is not completely illogical, because Mr. Song, even though seeking a divorce could have continued to allow the affidavit of support to remain in place. What's unreasonable about that?
Well, again, that would still remain essentially a unilateral veto here. There's nothing about the divorce where Mr. Singh would have to consent to that. As far as I know, I'm not an expert in divorce law. And it just, to our argument is this, essentially, when it boils down to this, in this circumstance, the applicant here, the non-citizen here, should continue to be treated as someone who's essentially abroad. They're still trying to get here. And that's because of the reliance that she's placed on it. Under that scenario, if she was treated under the second section of the regulations, Mr. Singh's withdrawal of the affidavit of support would not have any legal effect because she's already disembarked from Cambodia, flown all the way over here and set up her life here. Under those circumstances, an immigrant visa cannot be revoked. And without revoking an immigrant visa, you can't withdraw an affidavit of support. If you want under CSA to establish a way for a person like Ms. Song to continue to adjust status, then you should protect her from a unilateral veto by the petitioner. And it's a very simple remedy. You just continue to treat her like she's abroad, like she's an applicant for an immigrant visa. You don't treat her like she's an adjustment of a status applicant, because that exposes her to that unilateral veto. Failure to do that, we believe, is unreasonable. The court unreasonably failed to consider this and continued to assert that it just had no jurisdiction over regulations. And we're not asking for this we're not asking for any kind of different treatment. We're not asking to freeze the adjudication at any odd time. We're simply saying that she should be permitted to present a substitute sponsor, and that she'd be able to do that if the withdrawal of the affidavit of support was not given legal effect. Thank you, Your Honor.
Thank you, Mr. Eccles. All right, we'll hear from the government.
May it please the court, my name is Nilam Isanula, and I represent the United States Attorney General in this matter. The court should find that the agency properly denied Ms. Song's application for adjustment of status on the basis that she was inadmissible as someone likely to become a public charge. It should be noted here that Petitioner Song does not challenge the fact that she was obligated to provide an affidavit of support from the individual who filed her underlying fiancé visa petition, here Mr. Singh. Her only argument really is that Mr. Singh should not have been allowed to withdraw the affidavit of support, citing the regulations at 8 CFR 213A.2 F1. But as we've discussed as my friend opposing counsel has discussed, there is a difference. There is a difference between F1 and F2, and F2 is the clearly applicable provision to Ms. Song. If we look at these two regulatory subsections, they clearly map onto the two different ways that an individual can obtain a permanent residence, or what we call green card status informally. F1 maps onto the consular processing process, while F2 maps onto adjust.
Counsel, if I could just interrupt you, because I think I understand where you're going there, and I think your colleague largely agrees with that under the regs it's different, and if applied strictly, the withdrawal here would be okay. What he says is that the CSA case provides leeway in certain areas, particularly with respect to 1255D. And it's kind of unreasonable to grant that leeway there in the case of divorce, but not here. And doing so exposes clients, people like his client, to reliance sort of situations. What's your response to that?
Matter of CSA is a limited case. It doesn't have the broad applicability, the broad sort of holding that the petitioner is arguing for. Matter of CSA was addressing mainly the fact that there are two requirements in the adjustment of status statute that don't have clear or they have very confusing application to K-1 visa holders. And that's the requirement that you have an immigrant visa, that you're eligible for an immigrant visa, and that the immigrant visa is immediately available to you. These are provisions that don't map onto the K visa context, where an individual is actually applying for adjustment of status based on a non-immigrant visa petition, the approved fiance visa petition. So the matter of CISE was really addressing what they called the absurd result of disqualifying all fiance visa holders from statutory eligibility if they were to read all the statute literally and apply the immigrant visa requirements to K-1 visa holders.
Well,
So
it did, counsel, it did that, and that was one part of the holding, effectively regarding subsection A, that's kind of nonsensical to have A be only for immigrant visas if you have the whole K-1 process. So that's one thing, but I think what counsel is maybe talking about, maybe I'm wrong, but with a little more emphasis, is the holding with respect to 1255D, where it seems like CISE pretty much ignored the plain language of D. And maybe you don't think that's what it did. I'm curious to what's the Attorney General's position on whether CISE is reasonable with respect to that second issue about the, failure to consider, divorce in relation to subsection D.
I understand what you're talking about, Your Honor. I do want to kind of keep going with that discussion because it bleeds into each other. So the fact is that, the board in CISE really had to create that legal fiction in order to make sure that the adjustment of status process was available to K-1 visa holders. And so the DHS at that point was, well, if you're going to apply this legal fiction that, treats these individuals as immediate relatives, well, then Mr. CISE should be denied on adjustment of status on the basis of the fact that he is no longer married. And so he doesn't meet the visa classification of an immediate relative if he was to be treated like the spouse of a US citizen outside the K-1 fiance context. So the board said, well, no, we are not going to extend the legal fiction that far. And so it said, Mr. CISE is, instead of, proceeding on the basis of an I-130 visa petition, the type of visa petition that extends to spouses of US citizens outside the K-1 context, Mr. CISE proceeds on the basis of the fiance visa petition. And the regulations there do allow, they are silent as to the effect of divorce on the petition, on the underlying petition. So because the regulations did not require revocation in the case of divorce, the board was declined to extend that legal fiction and allowed Mr. CISE, who had divorced subsequent to his admission on the K-1 visa, to obtain adjustment of status. And so these holdings kind of bleed into each other, but it's important to note
why
that—
shouldn't someone who divorces prior to adjustment of status be accorded that same opportunity, that the sponsorship not be withdrawn, or at least that they could substitute a sponsor?
Well, do you mind explaining that a bit more? I mean, I can answer why they shouldn't have to provide a
Why should
sponsor.
someone in petitioner's petition who came over here in good faith and married Mr. Song be subject to the whim of Mr. Song divorcing her prior to adjustment of status and then withdrawing sponsorship, so she is now considered a public charge?
Okay, I understand your question now, Your Honor. I mean, so
and then Mr. Song could just find somebody else to bring over and marry for a year and divorce and send them back, and find somebody else. Why is that? That doesn't seem reasonable.
Well, what you're mentioning here, these repeat fiance visa petitions, they actually are a concern that Congress had. And Congress enacted protections into the fiance visa context that addresses repeat fiance visa petitions. It essentially bars them. I can't remember the exact number. But so addressing Ms. Song's case—
that impacts Mr. Song. But if you're the first person in the chain, like petitioner is, what's the protection for her?
Well, the protection is that she, is able to adjust her status. That the divorce alone does not serve as a bar to adjustment. However, she still has to have the cooperation of the underlying fiancé visa petition sponsor, and that is
So
the
that
reason
goes
why
back
that's
to the imbalance of power argument that opposing counsel was making.
unfortunately it's a product of the statute. The statute plainly and the regulations, which plainly require that the affidavit of support has to come from the fiancé petitioner. In this case, Mr. Sang. This Miss Song does not challenge this fact.
That's a recipe for abuse and domestic violence and control in these marriages.
Well, if there is,
They
I
could
understand.
the spouse, the sponsoring spouse could just threaten constantly to withdraw the sponsorship up
But
until. Go ahead.
Thankfully, the INA does address the situations of abuse that you're speaking of under VAWA, the Violence Against
Right.
Women Act. Yes. So if there is a situation where the citizen spouse is holding, the visa petition over this individual's head and using it to cause abuse, it can be a basis for a self-petition on an I-360 form. But then again, we're getting out of, this is not what she's alleging. She has not alleged abuse, but that is an exception that's recognized to the affidavit of support requirement. And that's one of the points the board makes, that there are recognized exceptions to the affidavit of support requirement in the statute, but they simply don't encompass divorce. Divorce is not something that exempts you from having to file an affidavit of support from the spouse who filed your underlying visa petition.
It may not as a matter of theory, but as a practical matter, I mean, CISA may be the exception to the rule. Of course, we don't know, we have no record evidence of how likely it is that a divorce sponsor is going to remain a sponsor after a divorce. So, but as a practical matter, doesn't that make it almost impossible for a petitioner in Ms. Song's case to adjust status?
Well, as the board mentions, it is possible that there are going to be situations where the individuals in the marriage contract, and she might waive her ability to sue under the contract, and he might agree to proceed with the affidavit of support. The affidavit of support has a very low financial, from place of privilege, it's low. It requires that the petitioner provide, the sponsor provide support that's equal to 125% of the federal poverty guidelines. You can imagine that there are situations where in divorce, people are already paying sums that are higher than this, and they might be willing to continue with the affidavit of support and stay on to benefit the other side. But either way, these sort of policy considerations were sort of a bit on dangerous ground. Recently in Patel, the Supreme Court explained that there is no jurisdiction over a decision regarding the granting or denial of adjustment of status. And so this case is, a typical decision regarding the denial of adjustment of status. Petitioner has, I think, Ms. Song has preserved legal questions under 1252 A2D. But if she's going to raise these sort of factual arguments and policy arguments, we veer into territory that Patel might cover, because in Patel, the Supreme Court said that factual questions underlying the denial of adjustment or granting of adjustment are unreviewable. And so we do have to stick to the legal questions here. I would also.
So what is your response to the USCIS saying that it is reasonable to conclude that a sponsor's ability to withdraw the form 864 is governed by F1 rather than F2?
Do you mean the minutes that were put into the record for the motion to reopen case?
The question and answer from the USCIS, and the answer being it is reasonable to conclude that a sponsor's ability to withdraw blah 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 is governed by F1 rather than F2.
I think that that is a tentative position. It's not official, and it seems to be as my friends suggest, that it seems that there was some sort of going back and forth at the agency level, because AILA is suggesting with its questioning that it's getting denials that go the other way. So it's a bit confusing. But what we do know is that it's tentative.
It then
and
says,
unofficial.
in other words, USCIS believes that if the petitioner has submitted the form, he or she cannot, and that's italicized, cannot validly withdraw it after the date of the K non-immigrant admission.
I mean, so if it is USCIS saying that F1 should govern, we know that 1 month later, USCIS denies Song's application for adjustment of status using a completely different position. So they're saying that they denied because Mr. Singh could withdraw his affidavit of support under F2. So
And did he? I know he filed
not,
I know he asked to withdraw it. Where in the record did he? He actually did. He was actually granted permission to withdraw it.
He filed a letter informing USCIS, and so as part of the adjustment denial, they indicate. I don't think that they have to grant. There's any
so it's just as part of, it's assumed in the adjustment denial where they say because you don't have a sponsor anymore. That he withdrew.
Assumed what exactly? That it notes that the letter, the I-485
that he withdrew. You're saying they say that
it has been withdrawn.
Right.
Yeah, at page 187, USCIS says that the affidavit of support has been withdrawn. USCIS has received a withdrawal from the petitioning sponsor, Mr. Singh. So I mean, one of the, I think, important points to mention is that to the extent that petitioner wants to rely on a co-sponsor, seems to believe that she can rely on a co-sponsor, this is plainly contradicted by the statute. There are only 2 provisions in the INA that allow for a non-petitioning sponsor to submit an affidavit of support. And those 2 situations are joint sponsors and substitute sponsors. Joint sponsors can come in when the petitioning sponsor does not meet the income requirements for the affidavit of support. A substitute sponsor can come in when there's a death and the substitute sponsor is related in some familial way to the non-citizen. But neither of these situations cover this context of divorce, of dissolution of a marriage. And so again, we're left in a situation where the INA has created exceptions that don't bear on the divorce context, that suggest that divorce is not something that is exceptional in terms of the affidavit of support requirement. Just going back to matter of CSE, it's important to, I think, consider the fact that as Your Honor has already pointed out, CSE did not address the admissibility requirement. And crucially, it did not say that the admissibility requirement was ambiguous, which is what it said about the immigrant visa requirements. It points out that under both the prior K-1 adjustment statute and current law, non-citizens are obligated to establish their admissibility in order to procure adjustment. I think it's very important to point out that the prior K-1 visa adjustment statute actually also included an admissibility requirement, because it takes away the idea that the statute is ambiguous in the context of that the language about admissibility is ambiguous in the 1255A context, because as long as the K-1 visa category of non-immigrant petitions has existed, it has been required that they show their admissibility, that they are otherwise admissible as part of their adjustment of status application. Matter of CSE simply results from dealing with ambiguous statutory provisions that aren't relevant to our case, where we're talking about the admissibility provision of 8 U.S.C. 1255A2. The holding of CSE can't be read as broadly as petitioners suggest. The idea that every time we see the term immigrant visa cases in the INA, that idea that it means it covers K-1 visa holders simply doesn't bear out. If we read
Counsel, can I ask a question? So if the sponsor in this case had gone overseas and married Ms. Song and then sought to adjust status by bringing her back to the U.S., and somewhere along the way withdrew his petition for support, affidavit of support, could Ms. Song have relied on a substitute sponsor in that context?
So let me just make sure I understand the situation. Miss Song or
In other words, it's not a
hypothetical-
K1, it's not a K1 visa,
Not a
not a
K1.
90-day visa. It's a situation of a US citizen marrying a spouse overseas and then
Yeah.
seeking to adjust status. In that context, if there's a divorce along the way and would that spouse then be able to get a substitute sponsor?
No, Your Honor. And also that the divorce, as matter of CSA points out, the divorce in the immediate relative context, it will terminate the I-130 petition. So that immigrant visa case just goes away. But also this, we know from the substitute sponsor provision in the INA, it's only triggered by a death. And it requires that the substitute sponsor be somebody related to the non-citizen. So that the substitute sponsor provision cannot help the non-citizen in that case. It's also, though, your hypothetical drives point, in many ways, Ms. Song is more she's luckier than that immigrant visa who's divorced, the individual coming over for the immigrant visa. She can at least still pursue adjustment of status. She just needs to have the cooperation of Mr. Singh and for purposes of the affidavit of support. The immigrant visa person doesn't have that luck, doesn't have that same situation. Unless there are
Did
other
the
questions.
BIA acknowledge or consider this ALA question and response that I read to you earlier?
When they denied the motion to reopen, they said that was not new evidence and it wasn't sufficient. It was kind of like legal argument. So it wasn't sufficient for either a motion to reopen or a motion to reconsider.
Initially, did they consider it?
I think they considered what provision applied to Ms. Song and Mr. Singh. In matter of Song, we see them, they say that he was permitted to withdraw the affidavit of support under F2. They cite F2 on both of the last pages of that decision. So they're clearly believe that Mr. Song.
Counsel, you're about to run out of time and I don't think you answered the question. And the question was whether or not the BIA considered that guidance from USCIS in their initial decision.
No, I don't believe the guidance was brought to the agency's attention. That was the basis of the motion.
Well,
to
you
reopen.
used this decision. You used the fact that the agency made their decision after this guidance as a reason that this guidance shouldn't be followed, but they didn't even consider it. Earlier, when I asked you about this guidance, you said, "Well, it's not applicable because they didn't apply it."
Your Honor,
Basically.
I think I'm confusing you, unfortunately. So the
Yes.
USCIS ALA minutes came out in October 2012, and then in November 2012, the USCIS denies the adjustment of status application on the basis that F2 was applicable and he could withdraw his visa, his affidavit.
Right,
of support.
and they didn't consider or acknowledge this guidance in doing so, correct?
They didn't, because there's no evidence that this guidance is binding, and it's not like the matter of Song, which is a published board decision.
But it
that's
might make
controlling.
their decision unreasonable to the extent they didn't consider it, even if it's not binding.
It's unofficial policy, and it seems to be, not a long-standing policy at all, considering that in 1 month's time they're reconsidering it if they are. And either way,
you said they didn't reconsider it. You said they didn't reconsider it because it wasn't new evidence.
At the motion to reopen.
And now you're
level.
saying they did reconsider it.
I'm sorry,
Anyway, they didn't consider it.
confused.
We can agree to that. They did not consider it, correct?
But either way, it's unnecessary for them to.
I
consider
understand
it.
your argument.
All right. Thank you, Your Honor.
Thank you. Mr. Eccles, you've got some rebuttal.
Thank you. Thank you, Your Honors. I want to, first of all, start by addressing those ALA minutes. And I just want to be clear again here. I don't want the court to end up in a position of feeling in any way misled. At page 47 of the administrative record, the part that's underlined by and emphasized by pen, it's now my reading of these minutes that part that is underlined is, I just want to be clear, I no longer think that part is a statement of a position by the government. It seems to me that
Right.
it's
Go ahead.
a restatement of Ayla's question. So I think what DHS's position is more spelled out in the four or five paragraphs that come after that. And I don't believe that they support my position. So I just want to be very clear about that. And I think what the government is arguing here, what my friend is arguing here, is that even if this represents an ongoing conversation behind the scenes between, the advocacy that Ayla conducts, all year long, and decisions the agency makes, I believe they're arguing that the decision obviously reflected that in the end, in this case, the government did not take the position discussed in these minutes. And I understand that in this case, we are simply, in this case, an affidavit of support was filed by the sponsor. It was filed. At which point, let's say the sponsor had shown insufficient income. My client then would have been able to secure a co-sponsor and meet and defeat this ground of inadmissibility. All we're asking is that given the unique circumstances of a K-1 visa and adjustment, that section F1 be applied, which would mean that Mr. Sang's withdrawal of the H-64 would not be given legal effect, which would mean it's still there. And all the agency has to do is consider it as zero because he's not participating, obviously, symbolized by the divorce, and allow her to have a co-sponsor to go with it, since the 864 would still be there in the record. That's all that would be required for matter of CSE to then have full effect, where here, a matter of CSE is undermined by the unilateral veto of the petitioner simply sending a letter stating that they'd like to withdraw the 864. We're not asking for a reshaping. And again, as far as Chevron goes, I'd just like to point out the statute, there may not be the same ambiguity because we're not dealing with the same situations in CSE. CSE is settled, but the statute itself makes no comment about, at least none that I can find and none that I think the government has cited, about the withdrawal of the 864. That's not anywhere in the statute. It's only in the regs. And so there's really, I don't think there's really any reason why the agency here can't use the same creativity that it used in CSE to apply the immigrant visa section of the withdrawal rules rather than the adjustment of status rules. And Your Honor, your question about the hypothetical of someone immigrating, if they married in Cambodia, she would land, and they did the immigrant processing at the consulate in Cambodia. They would land here, she would land here with her green card. She would instantly be a lawful permanent resident. Her reliance would be rewarded with her status. The weird thing about the fiancé visa is she lands here still with no permanent status. And the complexity of the structure is all about trying to protect against fraud, but still provide for a non-immigrant fiancé to arrive and have a process of then completing the arrangement. And so that's why we think she's still more analogous to that immigrant visa context rather than the adjustment of status context. The reliance issues are completely different. So, Your Honor, unless you have more questions, for all of those reasons, we would request that you not apply Chevron deference to this case in matter of song, and that you either vacate the decision and issue a decision of your own, or that you simply vacate the decision and remand the matter for further consideration of these arguments about the regulations. Thank you, Your Honors.
Thank you, Mr. Eccles, and thank both counsel for their arguments this morning. We appreciate it very much. And with that, the court will stand adjourned until tomorrow morning.
Thank you, Your Honor.